A three-judge bench of the Court of Appeal led by presiding Judge Daniel Musinga, Agnes Murgor and Patrick Kyage will make a determination in 11 days' time as to whether the suspension of the clauses in the security law was constitutional or not. On the 2nd of this month, Justice Judge Odunga suspended sections of the controversial new security law, which was enacted by Parliament late last year amid fierce opposition. CORD had moved to the court claiming the laws violated freedom of expression and fundamental rights of Kenyans. However, the Attorney General moved to the Court of Appeal to try to overturn Justice Judge Odunga's ruling, and in his argument he says that the judge erred by issuing conservatory orders and that the orders ought to have been granted by a bench of more than one judge. But CORD lawyer James Orengo says the appeal is defective in nature as it was filed outside time.
Because your jurisdiction in party is based fundamentally on the notice of appeal. And if there is no competent notice, if there is a defective notice, then, my lord, you must down your tools because there will be no jurisdiction.
To which Githu Muigai replied that the court should not address itself to technicalities but substance of the application.
Are they irreparable errors? No. Should constitutional litigation be conducted?
However, John Haminwa, representing Kituo cha Sheria, said that there is no vacuum in our current law that would make the state panic.
That is a fact that your lordship cannot afford to ignore at all. Yeah, you cannot afford to ignore that at all. Well, the Chief Justice has already exercised his powers under Article 164.4. Having done so, the question arises, can your lordship then go ahead and interfere with the orders made by Justice Odunga?
Nzamba Kitongo and amicus curiae said that the verdict that was entered into by Justice Judge Odunga was well within the confines of the law.